All right, we're super excited to have Megan Spadell with us tonight, and she is going to walk us through the legal steps in foster care, all the way from the initial phone call that comes in, all the way to the appeal process that happens in the court. And so rather than hear me talk as we go through this, I want to turn it completely over to Megan at this point and let her get every second that she can in with us tonight. So Megan, you want to get up on the screen and start going?
Awesome. Can everybody hear me? Okay. So I'm Megan Spidell Beaver. I am the owner of Spidell Family Law in Greensboro, North Carolina. I practice primarily family law in Guilford County, Rockingham County, Randolph County, Alamance County, Forsyth, Davidson. I think that's all of them. And I've been doing family law for almost 10 years. I do a lot in abuse and neglect dependency court. And I am a brand new foster parent. My husband and I just got licensed. Officially, we got our call, I think, on January the 20th. So we're excited. I'm very happy to be here and talking about something that I'm passionate about, which is how the court process works for foster care and in abuse and neglect and dependency court. Like I said, I've practiced family law for almost 10 years. I've practiced in juvenile court from essentially the beginning. And I was passionate about this process before I got involved in being a foster parent. And once I joined the Facebook group that most of you are all in and probably found out about this through that process, realize that there's a lot of questions involving the court process and what that looks like, and a lot of unanswered questions. And so what I wanted to do here today is treat this as an informational session. It's not meant to be legal advice. I have to give you guys the disclaimer that it is also not forming an attorney-client privilege. So don't go back and say, well, my lawyer said X, Y, Z. This is truly just for your informational purposes and to answer a lot of the questions that I'm seeing popping up in the Facebook group that I've had people text me and ask me about. There's just a lot of things that there's a lack of clarity about. And part of that is that, you're not involved in the court part of this process. Even if you go to the court dates, you don't always necessarily know what all the legal terms are and what all of that looks like. So with all that being said, I know some of us are brand new foster parents like my husband and I are. Some of you are seasoned foster parents. And I see a question already popping up, and I'm definitely going to get to that one at the end of the presentation. So I wanted to start, and let me see if I can get my screen share to work really quick. I'm going to start from the very beginning of what happens when a call is made to DSS, and how does a case come into foster care? How does a child end up on that list for you to get that call for foster care? And so the very first question I was going to ask, and I know most of you don't have video on, but it looks like there are 54 total participants. How many people in this group are mandatory reporters for abuse and neglect and dependency? And if you aren't raising your hand, it should be up, because everyone here is, unless there is a very, very narrow exception, which is if an attorney is representing one of the people that are the respondent in a abuse and neglect or dependency case in juvenile court. Otherwise, you are a mandatory reporter in the state of North Carolina. And so that is very important. Most of those reports are coming, or a lot of those reports are coming from educators, daycares, teachers, guidance counselors, people who are seeing the children on a regular basis, coaches. A lot of those reports come from other parents in the middle of a custody action. A lot of reports come from law enforcement after arrests, after overdoses, after accidents, after incidents of domestic violence. And a lot of reports are coming from judges in a custody court or in a DWI case where a child was involved. So reports come in very, very commonly. I have a few statistics that I wanted to throw out there because when I read them, I was somewhat astounded. And so once a call comes in to DSS, there are these people that are these social workers that are screening the cases. And so a call comes in, ring, ring, I believe that my child next door is being abused by their parent. You give the specifics, those calls can be anonymous. And once that call is made, there's a social worker on the other end that's going to determine whether that case is going to be screened in as possible abuse, neglect, or dependency, or whether it's going to be screened out and there's not going to be any further action. On the cases that were screened in, and these are statistics, I know there's more recent ones, but these are the statistics from 2017, 2018 fiscal year. And in that fiscal year, there were 70,000 cases that were screened in by the Department of Social Services in North Carolina in that year. 6,000 of them were coming from anonymous callers. 483 came from child care providers. 12,742 came from teachers. 13,408 came from law enforcement or court personnel. 9,872 came from medical professionals. 6,487 came from non-relatives. 4,298 came from the other parent. 7,290 came from the other relatives. And the one that was most shocking to me is 220 of them came from the child themselves. And so those are just some of the numbers of the cases that are screened into North Carolina DHHS every year. Of those cases in that same fiscal year, 3,843 of them were abuse cases. 4,600 of them were abuse and neglect. 626 were dependency, and 60,000 of them were neglect cases. And I'm going to get to the definitions of what those mean under the statute here shortly. So just making sure everyone knows that under the statute 7B301, everyone here is a mandatory reporter. So once DSS gets that initial call, it's going to go first to be that screened in or screened out. And if it's screened in, it's going to an intake social worker. That investigative social worker has to investigate within 48 hours of receiving that call. And it is being investigated to determine whether there's a need to remove the child from the home. In many cases, the social worker has the parent enter into what we call a safety plan or a safety assessment. You will probably never see those, but on my end of the family law side, there are these yellow 3 or 4 page forms that say, what is the concern? How can we alleviate the concern? And at the end of it, it'll say, it's either safe without a plan or safe with a plan, safe placed out of the home. And they give the parents the opportunity to make a safety plan for the child to address the issues. In that safety plan are listed the concerns of the for the safety, whether the parents can enter in a plan to keep the kids safe without removing the children from the home. In other cases, such as perhaps a domestic violence or sexual abuse allegations, the social worker can work with the family to enter into a voluntary out-of-home placement. So if you're a family member or a family friend, you may be able to be that temporary service provider that can provide that placement for the child during the investigation out of the home before the child's taken into foster care. So just because a report to DSS is made doesn't mean that and even if DSS finds that there are safety concerns, it doesn't necessarily mean that a petition is going to be filed with DSS. They do give the parents an option to place the children with somebody else that's safe. Only when it gets to DSS and there is no other safe plan for the child does DSS have to jump in and say either there is no way that these parents can keep these children safe, or there is no other viable option for placement. Maybe somebody's house, grandma's house isn't safe. Maybe Aunt Gina's house has too many kids in it. If DSS finds the need to file a petition, something has happened so severe in this child's life that they're having to be removed because there is no other person that can provide them a safe place to be. And so, as foster parents, we are taught in depth about how to deal with trauma, but to understand the backside of this and how they get to where they are, I think is really important. And so with those statistics, seeing that, a vast majority of them are neglect case. They're not actually abuse cases. And I want to show the court the timeline, or the court timeline of the process of how this works as we walk through it. And first, I'm going to go through what the definition of abuse, neglect, and dependency is. And this is also found in our juvenile code, which is chapter 7B 101 of our court statutes in North Carolina statutes. So the definition of abuse pursuant to the statute is a juvenile under the age of 18 whose parent, guardian, custodian, or caretaker inflicts or allows to be inflicted upon the juvenile a serious physical injury by other than accidental means, or they create or allow to be created a substantial risk of serious injury to the juvenile by other than accidental means, that they use or allow to be used upon the juvenile cruel or grossly inappropriate procedures or devices to modify behavior, commits, permits, or encourages the commission of a violation against the juvenile of rape, first or second degree by an adult offender, sexual act, unlawful sale or purchase of a minor. That actually happens, and there are people that try to sell their kids on Craigslist. Crimes against nature, employing or permitting the child to engage in activities violating the obscenity laws, so like child pornography, sexual exploitation, or promoting prostitution. And that's found in 7B 101. Creates or allows serious emotional damage evidenced by serious anxiety, depression, withdrawal, or aggressive behavior towards himself or others. Encourages, directs, or approves of delinquent acts involving moral turpitude by the minor, or commits or allows human trafficking, involuntary servitude, or sexual servitude of a child under the age of 18. So that is just abuse. And like I said, of those 70,000 cases in that one fiscal year, 3,800 of them were abuse only, and then 4,600 of them were abuse and neglect. So neglect is defined under the same statute as a juvenile who has not received proper care, supervision, or from the parent, guardian, or caretaker, or who has been abandoned, not provided medical care, or who has not provided necessary remedial care, or who lives in an environment injurious to the juvenile's welfare, or who has been placed for the care for adoption in violation of the law. And again, those kind of crossed over with abuse and neglect, but 60,000 of those 70 were neglect cases. And then the last one is dependency. And that is when a juvenile is in need of assistance or placement because either one, the juvenile has no parent, guardian, or custodian responsible for the juvenile's care or supervision, or two, the juvenile's parent, guardian, or custodian is unable to provide for the juvenile care or supervision and lacks the appropriate child care arrangement. So that's when I went, there's no other viable option. The form that I'm showing on the screen is the caretaker definition decision toolkit. And what that is showing is in box 1 on the left, is the person a birth or adoptive legal guardian or legal custody? If yes, that person is legally responsible for the health and welfare of that child. If no, does the person live in the household and is an adult? That includes foster parents, potential adoptive parents, and any other adult living in the home. And that is also, that person falls under that caretaker statute. Apparently something happened to my scan here, but the next one is it an adult relative, but they don't reside in the home? And again, this includes, I'm sorry, this is an overlap. The next one is the person an adult relative inclusive of people connected by blood as well as marriage, entrusted with the juvenile's care? And again, that person is considered a caretaker under the statute. So it doesn't necessarily have to be the custodial parent. And then the last one applies to people that are in a group home setting. Is the person the role of a house parent or a cottage parent? And that person is also defined by the statute as a caretaker. If they're not one of those things, they're not going to be defined by statute as a caretaker. So once the court has determined that they do, or the DSS has, and DSS is the only entity that can file a petition for abuse, neglect, and dependency. Once DSS has determined that there is no other option and they have to file, they can take temporary custody. And this often happens with law enforcement. So for example, children are in the back of the car, dad and mom are in the front of the car, they're pulled over and they're arrested for trafficking drugs, and they're both taken into custody, and there's nowhere else for these two littles to go. At that point, the law enforcement is taking those children into custody, and the first call they're making is to DSS to say, we've just taken these kids. You can only hold temporary custody for 12 hours before you file a petition and you ask for the court to enter an order for non-secured custody. And what that non-secured custody order is doing is saying, giving the rubber stamp to say, yes, DSS, you now have non-secured custody and you can place them somewhere else other than with their parents. One of the questions that was asked recently in the Facebook was, at what stage does a GAL get appointed? And everyone probably is familiar with your foster child's guardian ad litem. That guardian ad litem is pursuant to the statute 7B408. As soon as the petition is filed, they are supposed to send that petition to the county's guardian ad litem office. And if it is an abuse case or a neglect case or a combination that includes one of those two, the statute is mandatory that a guardian ad litem is supposed to be appointed. And I know somebody said that they have not heard from their guardian ad litem. You need to be calling a supervisor because that is not correct. And then if it's a dependency only case without any abuse or neglect, that is discretionary and up to the court. So there are some cases where there won't be a GAL, but if you look at the numbers of that fiscal year of 70,000, there were only 626 cases that were dependency only. Anytime it's combined with any of those other things, there should be a guardian ad litem appointed pretty much within 24 hours of when that child is taken into custody. Most counties are going to have a GAL office that is staffed by a GAL attorney, and then they have volunteer advocates. And some of the smaller counties don't. And so it's important to note that there has to be an attorney involved. Like Guilford County, most of the counties that I practice in, they're larger. They have a guardian ad litem office. So that person has an attorney, and then there's a supervisor, and then there's the actual guardian ad litems that are working with your kids. Some of the more smaller counties don't have that, and they're just going to be appointing an attorney directly as the guardian ad litem. So you might just have an attorney from the list. The GAL that you are likely in contact with is not the person that's actually reporting to the court as the attorney. There's likely a level of reporting going to the court. So once you've filed that non-secure custody and you've taken those children into DHHS or DSS, I use those interchangeably. It's the Department of Social Services, the Department of Health and Human Services. They're basically the same thing. And it's also CPS. So we have DSS, Department of Social Services, DHHS, which is Department of Health and Human Services, and CPS, which is Child Protective Services. They're all the same thing. So once they've taken that child under the statute, you have to have what's called a non-secure custody hearing within 7 days of the removal of the child. So that section of the case The judge is determining whether or not the child should stay in DSS custody or if there's some other option. Keep in mind that throughout this entire process, all the way up until the TPR, the parents are working a case plan with their social worker. And I think that that is something that people often forget once they get the littles in their home, is that the parents hopefully should be, that's the point of the process, working that case plan from day one to work towards getting that reunification. The plan is going to be reunification until the court says otherwise. Even if the change of plan is entered, reunification is still kind of kept as a backup plan as well. So they're going to be working with their social worker, and they're going to be trying to check all those boxes off the entire time. A small point, and I'm not going to get into any of this at all, but if the child is of American Indian descent, that is a whole separate process. They have their whole different process. And so things get a little crazy there, and I'm not going to go into all that. It would take up way too much time. So once you've had that 7-day hearing, the court is going to have a second 7-day hearing. So we're at day 14. And we're going to do that 7-day hearing again and say, have they come up with another viable option? Has a kinship family member stepped forward to say, I want to sign up for a home study. I want to take these kids. Is grandma available? Is Aunt Gina available? If not, then after that second 7-day hearing, we're moving to every 30 days. And so you see a lot of posts on the Facebook that people are complaining, for the most part, about how long it's taking for these cases to go. COVID got everything 10 times more backlogged than it was before. And these cases, at least in the counties I practice in, were pretty backlogged before that. And so you'll see this is, and I can email this all to Gail if Gail wants to send this out, but you can see that there's a lot of different things that are occurring kind of at once. So you've got the child here in the middle, you're on the non-secure custody hearing, and you're going to have a pre-adjudication hearing. And at that pre-adjudication hearing, I'm just going to read what the goals at that point are before you get to adjudication. And so at this point, the children have not been determined to be abused or neglected or dependent. That happens at the adjudication. There's all of this happening before you even get to adjudication. At the pre-adjudication hearing, the court is going to consider whether their court-appointed counsel should be kept or released. And that's important to note that everybody who has a petition, every parent who has or caretaker that has a petition filed against them is entitled to court-appointed counsel from the very beginning. So whether or not that attorney is going to stay on or not, and a lot of times that decision is based on whether or not the parents are showing up and participating. If they're not going to keep the attorney on the hook for each court date if the parents aren't even showing up. You're going to have to identify the parties. One of the big things at this pre-adjudication hearing is whether paternity has been established. You have a lot of unknown fathers. You have a lot of maybe multiple option fathers. I have one right now where Jesus was named as the father. It's going to be very difficult to serve him. And so, whether there's relatives or parents with legal custody of a sibling that has been named as a potential placement for the child, whether all of the service on the known parents has been obtained and they've been properly noticed, whether the petition has been properly verified that's given the court jurisdiction, any pretrial motions like appointment of a GAL for a parent. If a parent is under 18 or is incompetent, then they are entitled to a GAL themselves that's separate from the GAL for the child. So all of that is addressed at the pre-adjudication hearing conference. And then we move towards adjudication. And I've seen a lot of posts about how long it's taking to get to adjudication. And unfortunately, it's taking longer than it should be with COVID. Usually it is supposed to happen within 60 days of the initial petition. I know cases that have been well over a year before adjudication actually happens. And if you have one of those littles, it may be that they're never adjudicated. because they're returned home, the petition is dismissed. The parents have done everything that they're supposed to do before they even get to that point. If they do that, DSS does have the option of dismissing their petition. Typically they don't. So they're going to continue this process even to get through to adjudication and disposition. So adjudication is where the court is determining whether there has been abuse, neglect, or dependency, as I defined earlier. If there hasn't been that proven to the court, then that case is going to get dismissed right there. It doesn't even go any farther. If it has, then it's going to proceed to the disposition. And most times those are done on the same day. Depending on how long the hearing lasts, though, those can be broken up. If all of the safety concerns have been addressed prior to adjudication, like I said, DSS may or may not dismiss the petition. And then at disposition, this is often going to happen the same day as adjudication, but it could also take place at a later date. But if it's going to be a later date, it has to be within 30 days of when the adjudication happened. So that's when the judge is going to determine what is going to happen to the child, what is in the best interest of this child at this point. That's determining placement, that's determining visitation, and that's determining what services are needed for the child and for the family. And keep in mind, all throughout this process, that the parents are still working that case plan if they're doing what they're supposed to do. Once adjudication and disposition has occurred, you're going to have a review hearing within 90 days to see have the parents made any progress, what's going on, and every 6 months thereafter. And so you see now that we're, several months down the road, and there's really no solidified decision on what's going to happen to these kids at this point. So they're going to consider at those review hearings the progress of the parents towards their plan. They were going to review the ongoing need for the child to be placed out of the home. If the parents have checked every single box on their safety plan, their case plan with their worker, then they can probably go home. If not, then they're going to continue that case plan and they're going to continue it out. Eventually, a parent is either going to sink or swim. They're either going to complete their case plan or they're not. And if they don't, then we may be moving towards a change of plan when we'll get there in a minute. But one thing to note, at these review hearings, the court is going to receive reports from DSS, guardian ad litem, the parents' attorneys, and the foster parents can speak up at these points. I hope I get to what you should say if you're addressing the court as a foster parent today. If not, we're coming back on March 16th for part 2 of this hearing, and I would encourage you to sign up for that. So here we are. We've had the adjudication hearing in the middle. You guys can see the screen, right? Hope so. Somebody give me a thumbs up. Okay. So once you've had the adjudication hearing, and you'll see the little notes there that reasonable efforts need to be made towards progress within 60 days. You're at the dispositional hearing, and at that hearing, the court can determine that we're ceasing the reunification efforts. And so you don't even you still have to do the review hearings, but the court can determine at disposition that the parents have done nothing towards their case plan, that they're not going to be able to reunify with these kids, and the court can cease reunification at that point. Either way, whether the judge ceases reunification or not, we're still moving towards that permanency planning hearing, review hearing. And we are eventually going to get to, I'm going to scroll down here. We're eventually going to get down to what's going to happen. We're either going to reunify and return home at some point, or we're going to move towards an alternate plan. So at that permanency planning hearing, which is held within 12 months of the initial removal, and then every 6 months thereafter, the court is considering what the permanent plan for this child is going to be. Is it going to be continue to be a reunification? Is it going to be guardianship or custody to a relative or kinship? Is it going to be termination of parental rights and adoption? And at that point, the court may change the plan. And this is what a lot of people have been asking on the Facebook as well, is what happens, how quickly, once that plan is changed to adoption, does all of that happen? And it's not as fast as you think. The court has 30 days from that hearing date to enter the order, the actual typewritten order that goes in the court file that changes the plan to adoption. And then from the date that that's entered, the Department of Social Services has another 60 days to file the actual termination of parental rights. So, you know, when the court moves the case to adoption, that court date, people get excited and they're like, okay, we're going to adopt this little guy. Not the process, and we're going to get into and I'm going to try to get through all of it today, but we're going to get into what that TPR process looks like, and also what the appeal process looks like, because the appeal process is something that really adds a lot of time to all of this. I'm going to briefly speak on what the court etiquette. There's a lot of questions about whether or not foster parents should attend the court date. I tell my clients, whether they're juvenile cases or not, knowledge is power. The more that you know about the court process, the more that you know where the future of whoever's living in your home is being decided by. The more you know about the judge and your social worker, the more that you show up and show your face. I think that's important. Recognizing that not everybody can take off that time. One thing that I will say about juvenile court is that it's not necessarily on any sort of schedule. And if you go for your hearing, you might be at 9 a.m. and you might sit there till 3 p.m. So, you know, if there is an emergency case and that emergency needs to go first, they're going to take that emergency case. If there's a case, for example, I have 2 cases on tomorrow for termination of parental rights in Guilford County. At 4 o'clock today, another attorney says, hey, your cases aren't going forward tomorrow because we have the first one on the docket and it's the oldest one and it's been pending for 3 years and it's going to go first and it's going to take all day. So that, you know, pushes things and pushes things and pushes things. If you do go to court, wear business casual or business attire or a suit. Don't wear sweatpants. Please do not wear pajamas or slippers. You don't wear hats. You don't want any parts of your body showing that shouldn't be showing. I typically tend to say, you know, if you have a sleeve tattoo, wear a long sleeve shirt. You know, things like that, that the court, you know, the court's watching and the court's seeing your face and seeing how you present yourselves. How do you address the court? The general rule is when you're speaking to a judge, you need to be standing up. You need to keep your hands out of your pocket. And if you put your hands in your pocket, the bailiff is going to yell at you. You're always addressing the judge, whether they're male or female, as your honor. You don't need to have drinks or chewing gum or snacks in the courtroom. In a lot of the counties, you're not going to be able to have your cell phone in the courtroom. So make sure that you arrange your childcare before you go into court. Because if you are the last case that's called at 4 p.m. and it runs till 5:30 and daycare closes at 5:30, you're going to want to have those arrangements made ahead of time. The foster parents report to the court. Most of the things that a foster parent is going to have to say is already going to be in either the social worker's report or the GAL's report. But you're not always going to get copies of those things. So if there are things that are extremely important to you that you want to tell the court, then it's important to do that, because you definitely want the judge to have a clear picture of what's going on in these children's lives. The court reports can be written or they can just be oral and you can give an update. If you're submitting a written report, you're going to want to title it the child's first name, first initial, middle initial, last name. You never want to put the child's full name on any document. And if you have your case number, you're going to have that, put that on there as well. Don't include your full name. Don't include your address. Assume that whatever you're submitting could be given and likely will be given to the biological parents or caretakers. So you don't want to include your address or, you know, grandma's address or anybody in your family's address. If you're going to do a written report, I would break it down into like medical, dental, therapy update, education, extracurricular, and how shared parenting and visitation is going. Those are kind of the key topics that the court's going to want to know about. If visitation is a disaster, if there's no shared parenting happening, if the parent is harassing you at 11 o'clock at night when they're drinking, the court wants to know that. If the child is doing amazingly well or excelling in soccer, the court wants to hear those stories too. You can write in full paragraphs or you can do it in bullet points. Obviously, don't include any profanity, even if it is, well, bio mom called me at midnight and called me an F and B word, write F ... G B word. Like, don't put that in a court report. Those are the same things that you would update the court on in an oral update as well. Typically, upcoming appointments like medical, dental, therapeutic, that's already going to be covered in the DSS and the GAL's report. General update on the living arrangement. How is he getting along with your kids? Does he have a favorite pet in the home? Mine are currently barking, so I apologize if you're hearing that. Does he have IEP upcoming meetings? Did he have a big project that he did great in school? General update on, are there any trips coming up with the foster family? I've heard a lot of complaints recently on judges not allowing children to go on vacation. I have a lot of feelings about this, and I've addressed it with some of our local judges. I think that it's important for children to feel included, and leaving them at home doesn't let them feel that way, especially if you're going on a fun trip. I also know that a judge recently has said you can't take the kid to Disney World with the rest of the family. So yes, COVID has, you know, restricted those concerns and it made judges more kind of hyper vigilant about those things. Ask anyways. A lot of times the parents will consent and the social worker will consent, and a judge still wants you to sign off on it. So don't just assume that you can go to Disney World with the kid, because a judge may ultimately say not to. So I'm going to talk about termination of parental rights because I think I have time to get through all of that as well. So the goal of terminating a parental right or termination of parental rights case. So once the judge has, and you'll see on the screen here, petition for TPR, that's termination of parental rights, and that's filed by DSS, or that's filed by somebody like me that is a private attorney. I actually have a contract with Guilford County's DSS, so I file both kinds. So I do private ones and DSS ones. You can also file a motion for TPR in the underlying juvenile abuse and neglect case. Typically, that's not how they're being filed. They're just being filed as a new petition. And so once we have ceased reunification and we are moving towards adoption and termination of parental rights, it's a whole new court file. The JA file is the juvenile abuse and neglect case that got them into court. And then you get a whole new court number, whole new case of a JT file, juvenile termination. It's a whole new petition. You have to get everybody served all over again. You have to get the bio parent or the known parent served, even if they're living at the Exxon gas station or behind the Taco Bell. And you also have to get unknown dads served. So you have to publish that in the newspaper, just like you've already done this whole process through the underlying case. You've now got to do it for the TPR all over again. So the goal of the TPR is when the parents have demonstrated that they will not provide the degree of care which promotes the health and orderly physical and emotional well-being of the juvenile, it is necessary for the juvenile to have the earliest degree of care at the earliest possible age, while at the same time recognizing the need to protect all juveniles from an unnecessary severance of a relationship with biological parents. And so you're weighing the necessity of having their emotional and physical well-being taken care of as quickly as possible versus the necessity of not unnecessarily severing a parental relationship with a biological parent. If the judge has ceased reunification efforts, that's called a change of plan, then that TPR has to be filed within 60 days. There are a lot of deadlines that aren't made in the court system. This one typically is. As if it's not, then it could lead to potential appeal by a parent later. The hearing is supposed to occur within 90 days unless good cause is shown for delay. Someone asked the other day, what is good cause? COVID symptoms, COVID diagnosis, judge had knee surgery, COVID exposure has been a big one. This deadline is very commonly not met. I just gave some examples. I have TPRs that are on the docket tomorrow that were filed at the end of 2020 that have not been heard yet. And they're not going to be heard tomorrow because the one that's 3 years old is going first. So the grounds, and I'm going to get my little statute book out because they're long and I didn't feel like typing them all out. But the grounds to terminate parental rights are the first step. So essentially, your hearing is going to be broken into two different types or two different parts of your termination of parental rights hearing. The first one is grounds, and of course, right this second, I'm not going to be able to pull it out. Here are the following things that the court is considering when they're looking at grounds. They're looking at abuse or neglect. Obviously, we've already talked about that. Willfully leaving a child in foster care for more than 12 months without reasonable progress towards your plan. Failure to pay a reasonable portion of the child's cost of care. So a lot of times DSS will initiate a child support action against a biological parent during this case so that they are required to pay for some part of the cost of care, whether that be the daycare vouchers, health care as far as Medicaid, the stipend that the foster parents are getting. All of that goes into the cost of care. Failure to pay child support to the other parent. So a lot of the times in my private TPRs, this is one of the allegations that we make, where a parent has failed to pay child support for more than 6 months and that parent has primary custody. That's one of the grounds in a TPR. Dependency, abandonment, murder, voluntary manslaughter, and felony assault of a child or a parent. TPR to another child has already occurred from the home and a lack of safe home. If a parent has relinquished the child for adoption. And if the child was conceived from a sexually related criminal offense. So the actual grounds that are listed are in the chapter 7B 1111. That is where the actual list of grounds are. And then the court looks at what is in the best interest of the child at the second phase. So if you get past the first phase and you only have to prove one of those grounds, you don't have to prove all of them, you don't have to prove 3 of them, you have to prove 1. So if you have a case where mom somehow murdered one of the kids in the home, that's going to be enough, obviously. If you have a case where one child was left in foster care for more than 12 months, which is a lot of times what's happening with the DSS cases, without making substantial progress on their case, then that is going to be grounds for TPR. You just have to meet 1. If the court says, yes, you've met grounds, then you're moving to what is in the best interest of the children. And the best interest, it takes into account the age of the child, the relationship with the biological parent, the relationship with the potential adoptive parent, whether there is an adoptive parent, how terminating parental rights is going to affect the relationship with the biological parent. And a lot of times, if a parent has failed to make efforts to their case plan and it's been more than 12 months, there may not be much of a relationship left at that point. And so if the court determines that there are grounds, check that box, the court is not required to still terminate parental rights. They have to also find that it's in the best interest of the child to terminate parental rights. And so that's extremely important. They want to make sure there's a permanent plan for the child. The permanent plan in DSS is typically going to be adoption. And so I don't know that we're going to get all the way through adoption today. I'm going to try to at least finish up TPR. If a parent's rights are terminated, they are no longer a party to the abuse and neglect case, even if the other parent is still moving forward with DSS. So they might terminate the parental rights of mom, but dad's still working his case plan towards reunification. The termination of parental rights, I saw this question asked recently, that order is required to be entered within 30 days of the trial. Again, there are some that are not being entered that quickly, and that is a reason for a parent to appeal. Once that TPR order is entered, it completely and permanently severs all rights and obligation between the parent and the child, except that a child's right to inherit if that biological parent dies does not sever until that child is legally adopted. So if a TPR order is entered and dad is a millionaire and he dies the next day, child can still inherit his $1 million, regardless of the fact that he didn't have any parental rights until that child is legally adopted. In DSS cases that they're not like not the private TPR cases, there has to be a post TPR review. And that's occurring within 6 months of the TPR being granted, and then every 6 months until permanency is obtained. So that's either going to be custody to a family member, guardianship, that kinship, guardianship, custody, or adoption. And so if a child their TPR is granted and 6 months down the road, they still haven't been adopted, then 6 months later, they're going to be having another one of these hearings to say, hey guys, what's going on? What's going on with the permanent plan for this child? Appeals TPR cases are one of the most commonly appealed things in North Carolina. And unfortunately, they are taking a really long time. Most TPR appeals do not actually require attorneys to show up, parties to show up for testimony. They're going to be based on the court file, and they're going to be based on the briefs submitted. And really, they're looking for an error in law, abuse of discretion by the court. The court did something that was just so wholly wrong that no one would have come to the same decision. And that's going to be based on, like I said, the court file and briefs submitted. Occasionally, if there's a new issue that the court has never addressed before, they may have the attorneys actually come and make oral arguments at the Court of Appeals. There was a brief period of time and I saw somebody talking about Supreme Court, when originally they were with the Court of Appeals. They go to a panel, they're decided in Raleigh. There was a brief period of time when they moved them to the Supreme Court, and then they moved them back to the Court of Appeals. So right now, they are held, these TPRs are determined, the appeals determined by the North Carolina Court of Appeals in Raleigh. So if you think that you're waiting on your county to do something, it's not your county, it's Raleigh. And I know this is something that Gail and I have talked about as far as change of plan orders taking longer than the deadline, TPR orders taking longer than the deadline. I would love to try to effectuate some change and get these judges to actually enter orders when they're supposed to. Right now at the Court of Appeals, I would expect your TPR appeal to take 12 to 18 months. If a parent is indigent and they're going to be appointed a parent defender who is going to file their briefs for them. And then DSS normally has an attorney who's filing the Court of Appeals that handles all of their appeals. If the attorney gets the case from the parent that appealed and there's just no basis to appeal it, they can file a point here. Once a TPR order is physically entered in the court file, the parent has 30 days to appeal. So if you've gotten past that 30-day mark, I saw somebody talking about that. If you're got past that 30-day mark, you should be in the clear that nothing's going to happen and that adoption can move forward. If they have no merit to their case and they've just filed the appeal because they're mad at the outcome, then their parent defender is likely to file what's called a no merit brief. And it essentially means that their case doesn't have any basis. And the Court of Appeals is probably going to be rendering a quicker decision on that because they're not having to really consider anything of merit. If the attorney determines that there are grounds for the appeal, then all of these deadlines are going to attach, and it's a lot. And this is what takes so long. You have to file your notice of appeal within 30 days. You have to get a transcript from the hearing, and I can send all of this. This is actually off of Smithmore Leatherwood. It's another firm, and it's just about general civil appeals, but the same deadlines apply. You've got to get a transcript of the case, and that is actually typed out. That's not a recording. Somebody's actually going to listen to the recording and type out the entire hearing. If it was a 3-day trial, they're going to type out every minute of it. And then after that, you've got you have to file the record on appeal. So every document that was every pleading that was in the court file, every exhibit, all of those have to be submitted to the Court of Appeals. And we haven't even gotten to the brief deadlines yet. So you see it's 15 days here, it's 14 days here, it's 30 days here. So we're already, several months out before the briefs are even due. Once you've gotten the Court of Appeals records submitted, then you have the briefs are due. And your reply brief is due 40 days later. The first 2 briefs are due within 30 days of each other. So you'll see all of this. They are considered expedited for the TPRs, but that's once all of this stuff gets submitted. And then here you'll see that the court is, if they require an oral argument, going to let everybody know that they have to come make oral arguments to the court. And then you just wait on their decision. So the entire process is taking quite a long time. I would say 12 to 18 months on the safe side. If you're lucky, it's going to come back faster than that. But I see 31 chats, and I hope that they're not all questions because I think we're supposed to end at 8 and there's only 7 minutes left. So.
Yep. So let's start from the bottom since it's got these questions. One is, can a foster parent file an appeal?
A foster parent is not a party to the case, so no.
Right.
The only people that can file appeals are the Department of Social Services or the private attorney that filed the petition and the parents who were terminated.
All right. Let's see. Some of these you've already answered. A parent or a parent attorney can appeal for any reason, and you answered that by saying a no merit brief. They
can appeal, and it's a very short document. It's just a notice of appeal. Take notice, court, that I'm appealing your order. And sometimes they just do it because they're mad.
Yep. Ellen, I'm going to park your question till the 16th about reasons for guardianship versus adoption, because we can get to that on the 16th. So since our foster son's older brothers have been TPR'd from mom, this is grounds for TPR for him as well?
That is one of the considerations, yes.
What if one parent has been incarcerated, the other parent is AWOL?
Incarceration alone is not a basis, but if they have abandoned the child, failed to make reasonable efforts, failed to send cards, failed to call, etc., but incarceration alone is not a grounds for TPR. If the other parent's AWOL, they're probably getting TPR.
Correct. For instance, one parent has refused to meet with DSS the entire time the child was in care, does not want the spouse to know the child exists, and has never met the child. The case heading to TPR, how does that work? Can they still appeal if they aren't listed on the birth certificate? And so I guess we're talking about the dad, or the absent parent.
If it's a spouse, then they are considered the legal father if they were married when the child was born. And they would be required to be notified of the TPR as well. If they were left off, people come to me all the time and say, well, he's not on the birth certificate, so he doesn't have any rights. That is not the case in North Carolina. If you were married when you had the child, or if you were the biological parent, regardless of who's on that birth certificate, you're still considered a dad. And what would happen there is that they would have to serve the spouse or any other person that could potentially be the dad. So they could still terminate mom, but they're not going to do it without dad knowing.
I'm going to skip over some of these that are really specific. Adjudication occur more than once? Can adjudication occur more than once? If the kids move to a new placement, does adjudication happen again?
A new foster placement?
Yes.
No, adjudication is only going to be happening once. Now, if for some reason the case was dismissed, I guess they could potentially refile the petition, but just moving placements is not going to reopen any door to adjudication.
All right. What time is required for father or the family of father to make a claim for a child once TPR is initiated?
I'm not sure I understand the question. Make a claim for the child. If they've initiated the termination of parental rights against the parents, there's not a claim for anybody to make within that. That's strictly with regard to the parents. Maybe I'm not understanding that question.
Well, I think, I mean, until the adoption has happened, they're still supposed to be looking for family members.
Correct.
So that would answer that question. I mean,
yes,
they can.
I understand what the question is now.
Yeah.
So the TPRs can still go forward against those parents, but yes, you are correct.
So foster son is now 33 days old, picked him up from the hospital at 2 days old. We're scheduled for the first non-secure custody meeting on the 1st. Is this common? Being over 30 days?
Is it common? It's more common than it should be. It's common, yes.
Okay, yeah. The scheduled non-secure custody hearing will be on the 4th, and the adjudication disposition is scheduled for the 11th. Are all these pretty much in line with what you've shared? This is her 6th child. All children were in the system. The 2 oldest are now adults. Less than 2 years ago, she TPR'd with the younger minors. The baby tested positive. No recorded history of receiving prenatal care.
Without giving legal advice, it sounds like she's on the fast track to being terminated, but there is not a fast track. So you're going to follow the same deadlines. And like I said, I can send this out. But you said the non-secure is just now scheduled?
Yes, for the 1st.
I mean, that was supposed to be done within 7 days. So right. I'm not sure what the delay was there. That's not proper.
Right. Max number of times that they can appeal. Once, right?
Yeah. I mean, there would be no reason to appeal a second time. I can't think of any reason that there would be appeal the second time.
Yeah. Can you elaborate on why the judges are stating they're not allowing kiddos to go on vacation, please?
I wish I knew that answer. I know recently, I think there's somebody else on the panel that said that they knew of this happening. I know there's been some COVID concerns. I know that judges try to, I don't know. I think the kids should be able to go on the vacation, and I've expressed that to some of our local judges.
All right, Jessica, I can answer that question. It's 3.5 years with no visits, came into care at 6 months and been with us 4.5 years normal to still not have a TPR hearing? No, changed to adoption 2.5 years ago and TPR scheduled 2 years ago. No.
Turn off and burn it up.
All right, two more questions.
I'll just say on that note that a lot of times the parents are doing just enough that the court wants to give them another 30 days or another 60 days to try to make those changes. And so, you know, they might not be checking off all the boxes on their court plan. Terminating parental rights is the most severe thing you can do. Having a child and having those constitutionally protected rights to raise your child, terminating those rights is pretty much the most severe thing you can do in the family law and juvenile sector. So the judges do give more leniency when a parent is making some progress, even if they're not making enough progress.
Mm-hmm. All right, last question, and then we're gonna drop the evaluation. So the last question is, besides contacting the casework supervisor, is there any recourse or action to take for a case where TPR was ordered and hasn't been filed for over 12 months ago and child has been in care 34 months with no parental contact?
Who all have they contacted? Because they need to go higher.
Yep.
Report it to Raleigh. I mean, that is definitely not correct.
Yeah. And so guys, and let me slip this in before we have been reporting things to Raleigh, and the first question they're going to ask you when you call the complaint line or fill it out, they're going to say, did you go chain of command within your county? And if you haven't gone chain of command within your county, they're going to throw it back down to the county. So make sure, go up your chain of command within the county first and then go to Raleigh with it. But yes, absolutely. And the person who asked that question, I would definitely be on the horn about that.
And so I think I saw that same post in the Facebook group, and just keep pressing and keep going up the ladder.
Yep. All right. So and the person who left that, if you want to message me privately, email or Facebook, either one, I'll help you with that. So I have dropped the form in the chat, and I'll stay on just a little bit longer so you'll have time. At the very bottom of it is the way to register for the 16th. We'll also drop that into the chat. Megan, this has been amazing. I have kept about 6 pages of notes that I plan on having available. You know, because we get calls all the time about this, and now I'll be able to say, nope, here it is right here. If you will send these forms to me, and when I send out the certificate, I will absolutely include the forms in with this. And we'll see you back on the 16th at 7 o'clock for another hour of this. And I'm 3 minutes over 8 o'clock. I absolutely am adamant that we stick to our time frame, because we all are tired. We're foster parents, or we work in this field, and we need the time. You are absolutely amazing at what you're doing, Megan, and we appreciate you.
Thank you, Gail, and thank you, Foster Family Alliance, for having me, and thank you, everybody, for tuning in. I'm excited to share the rest of it on the 16th. And can I get a copy of the chat questions so I can see if I can address any of the ones that weren't next time?
Yeah, before I hang up, I will cut and paste.
Awesome. Thank you. Thank you, everybody. Have a good night.
Right, you too. Thanks. Touch.
Nice job.
Thank you.
Nice
I'll see you
job.
soon.
That was a lot of information, but it was
A lot. I have so many more pages.
No, but it was, I mean, it was, the way you presented it was very sequential in the way that we need to see it. And so it started getting a little bit, a lot around the TPR stuff. So we may want to start back right at the TPR when we start back on the 16th and move forward. Let me cut the recording off.